All right, I'll open the meeting, waiting for Charlie Higginson, be here momentarily, I know. So it's Monday, April 11th, 2022 at 7:01 p.m. Zoning Board of Appeals of the Town of Cohasset. And so there's Charlie. And so we're going to open, we have a 2-item agenda. And I'll just, because we're on Zoom and being recorded, I'll just ask everybody to say present. I'll start off. I'm Woody Chittick, Chair, present.
Dave McMorris, Vice Chair, present.
Carl Higginson, present.
Lee Darst, present.
Matt Watkins, present.
And Mike Dickey is muted.
Mike Dickey, present.
There he is. Okay, great. All right, so as I said, it's we have 2 items that are really carryovers from last week. The first is a continued hearing, an appeal on the issuance of a building permit to construct a single-family home at 10 Ocean Ledge. It was filed by Ryan McCarthy, Esquire, on behalf of his client, Hollis Honeywell. So who is representing the appellant? Do we have Hollis Honeywell?
I just pulled Hollis up. He should be
Okay.
momentarily.
Can you hear me?
Yeah.
Yes.
Can you see me?
Yes. No?
Oh,
Yes.
now?
Yeah, you're a little soft, but
Oh, wait, I can turn up my microphone. How's that? Is that better?
yeah.
Yes.
Okay, good.
Okay, now this, Hollis, this is a 2-part process here. The first, where we left it off last week, was did you have adequate notice? Adequate notice. We're not going to pay attention too much to the 30-day notice period, tolling period, but did you have adequate notice of this building permit or not? And if you had adequate notice, it means you knew about it and you filed an appeal. And we shall go. And if we decide that you have a case to make because you did file in a timely fashion, we can either hear the substance of your appeal tonight, or we can continue this until our May hearing. But why don't you lead off first, Hollis, with your contention that your appeal was filed in a timely fashion.
Well, I gave Cassandra both my lawyer's timeline and my timeline, which you all have. I can read it if you'd like, but you have it in front of you. But I was prepared to appeal the building permit once it was posted. And I was told that it would be posted in the Cohasset Mariner and on the website, and it never was. And it wasn't until I saw a realtor on my driveway and asked what they were doing that I went to the town and found out that a building permit had been issued. Upon that, I immediately contacted you and the building department, and I hired a lawyer and I had him file an appeal, and he filed it and sent it to the planning board on December 20th, which was within 30 days of when I found out about it.
Okay, and that was information we didn't have in hand last week.
Correct. I wasn't.
No, I'm just for the
Yeah.
benefit of the public and the board. I mean, this was new information for us.
And so I provided, my lawyer has provided it, and I provided the timeline of everything that transpired. And I appeal that I did file in a timely fashion because I wasn't notified. If the town had followed its bylaws and posted this, it would have been very simple for me to appeal because I knew the process. Once I found out more than 30 days afterwards, I didn't know what I was supposed to do. So I appealed to the building inspector and to the zoning board to ask what to do. And I was told that you'd best hire a lawyer and do it as quickly as possible. That's exactly what I did. And the lawyer sent a letter to the town on the 20th, and you can see all the shenanigans he had to go through to finally get it filed. And that's just the facts.
Okay. Board, questions on this particular issue? The timeliness of the appeal.
Woody, I was just wondering, I know we just got some additional documents today. I don't know if it makes sense to ask John to speak before we do.
Before we do what?
Well, before we ask questions and give comments.
All right. John, you're out there.
Sure. How you doing? Thank you. Yes, I checked with the IT people. The public permits have been available on the public portal since January 2019. Since I've been working at Cohasset, there has not been any permits printed in the newspaper. This is the first I heard of it. So it's not a practice that has been going on. So it for a number of years anyway. So again, the portal was up there. The town hall has been open the whole pandemic there. So there's always a note left on the zoning and planning board if there's no one there to direct them to the building department for any service they need, as well as the town clerk's office. They could be dropped off there and stamped at any time, as they often are there. And again, it's the timeliness of the application and the awareness of when it was published. The information has been out there. It's just difficult to kind of. We have the same standards for anyone, any applications that we received via for permits going on now. We try to treat the same, and other people have managed to get their.
So is the process that we're following the process that is on the website, described in the website?
I believe so. Yes.
May I interject?
Sure.
If you go to the website right now and you go to the building permit, you go to the building department and you look up the building permits, they're all there. Every single one of them, over and over and over again. They were not there when the building permit was issued, the month after that, the month after that, the month after that, and the month after that. When I went to John Hanlon's office, when I found out about the building permit, and when I called his assistant, she didn't see it either because it wasn't posted on the website. How am I, who has stayed in touch with the Zoning Board of Appeals throughout the process, continuously asking, has a building permit been issued? Do we know anything further? How am I supposed to know that a building permit is issued if it's not posted anywhere? I have done everything in my control to stay in front of this issue. The sadness of this is back in 2004, this whole thing never got resolved correctly. Everybody involved knows it. This time around, I was ensuring that this would not happen again. I looked routinely to see if it was posted. I stayed in touch with the zoning board to make sure that a building permit hadn't been issued without my knowing it. And the zoning board didn't know about it. And I didn't know about it. And I only found out about it because somebody was on my driveway. And that's when I went to the building inspector. I don't know how a citizen of Cohasset is supposed to do any more than that.
Okay. Dave.
Yeah, I've got some concerns here. It seems to me that Mr. Honeywell's been probably more diligent than any citizen ever looking for building permits. It's pretty clear that the town was and continues to be in violation of its own bylaw that says that the building permits are going to be published in the newspapers. They're not. The bylaw hasn't been repealed, but apparently the practice has been. And instead, the public portal on the website has been used to substitute for that bylaw requirement. And I don't know what the story is, why there was the gap of posting them on the website, but I do not believe that Mr. Honeywell should lose his rights because the very
Because the
practice-
town didn't follow its own procedure.
Yeah, and it's the only way that citizens are going to be able to find out about a building permit. The appeal period is very, very short, and the penalties for not appealing within the time of the appeals period is very, very strict and harsh. So I think that the equities, and the facts certainly fall on Mr. Honeywell's side, or at least for the notice part of this.
Okay, other board members?
Yeah, Michael Dickey here. Where I'm kind of missing the thread is I'm more than willing to, agree that actual notice didn't occur until sometime in early December. But last meeting, I recall anyway that the appeal wasn't filed until somewhere in January, February. And so Hollis said tonight that the appeal was filed on December 20th. Is that factually correct, or did I miss something? Because the December 20th appeal time was not mentioned last meeting. So I guess I'm wondering where that's coming from.
Yeah, I think we've got to talk about this a little bit. My takeaway from last meeting was that there is no particular or ironclad form. Somebody had said, one of our attorneys, I think, said that a 2-sentence appeal would absolutely suffice. And we have a letter here from December 20th saying, Mr. Honeywell is issuing an appeal, or will be issuing an appeal, and further requests that any further actions or approvals currently pending before the town be stayed until a decision is reached on his appeal. It seems to me fairly clear that this letter of December 20th stands a pretty close proximity to an appeal.
Yeah, Woody, the only question I had on it, because I did think that the information submitted today was pretty informative. When I looked at some of the letters and whatnot, I think one thing for us to think about is somebody's intent to appeal the same as somebody appealing? I think the letters say that he intends to appeal. When did the appeal come in, right? Just something for us to think about.
I'd like to hear it from town council on that. I have a similar question.
Could I just interject? Or I guess I
Well,
can't.
town council's been asked to give an opinion, but
Sorry, did you want me to go ahead?
you might as well. Yes, please.
Sure. So, yes, I saw those documents today, as I guess everyone else did. And the point that Matt Watkins just raised is really the key question, I think, for you right now. And that is how to interpret the letter. So I'm looking at the December 13th letter.
20th letter.
Sorry?
I've got a December 20th letter. Do you have something earlier?
I have a letter from the law firm of Hamill, Marson, Dunn, Reardon, and Shea to John Hallen dated December 13.
Oh, I haven't seen that.
I have that too.
And you have a December 20 letter.
Whatever. I mean, it's not.
Yeah.
We're not
Perhaps
talking a
you're-
week here.
Yeah. So the first sentence said we've been retained by Hollis Honeywell. Second sentence, we are writing today to notify you of Mr. Honeywell's intent to appeal the issuance of a building permit that was issued with regard to the property at 10 Ocean Ledge. And the second paragraph begins, we also note that the forthcoming appeal is timely since Mr. Honeywell and others similarly situated and so forth have expressed their concerns promptly. So the question really for the board, and I guess I should find that December 20th letter if I have it, but
I think it's the same.
okay. Oh, interesting. Yeah. Is whether those references to an intent to appeal and a forthcoming appeal are actually should be treated as the appeal. That would be timely. The Mr. Honeywell got notice, and he was concerned about not having been notified about the issuance of the building permit. But I'll just remind you from our last discussion, that's not the date that we're using. The question under that newer case law that I described is when an abutter such as Mr. Honeywell gets adequate notice. So I think everybody's agreed that December 2nd, I believe is the date, would be the date from which the 30 days would be calculated. So this letter, whether it's December 13 or December 20th, clearly is within that 30-day period. So the question for you board members is whether the letter as it is phrased is actually an appeal or is an indication of an intent to appeal. That's the key question.
Was there a subsequent appeal? Something, a different document after December 20th that said this is an appeal, or?
Yes. So there was one, if you recall, we had different dates on that one too, but that's because it was dated February 14th, but it was actually only received by the town clerk sometime in early March. But in any event, clearly outside of the 30 days. And I do have the statutory language that describes the process for filing an appeal. And I'll read it to you. So this is in the Zoning Act, which is chapter 48 in section 15. And it says any appeal under section 8. So section 8 simply refers to somebody appealing a decision of a building inspector. So any appeal under section 8 to a permit granting authority, and that's a Zoning Act phrase for Zoning Board of Appeals. So any appeal under section 8 to a permit granting authority shall be taken within 30 days from the date of the order or decision being appealed. So now the case law, as I described, would be 30 days from the date of adequate notice. So here's the procedural language. The petitioner shall file a notice of appeal specifying the grounds thereof with the city or town clerk, and a copy of said notice, including the date and time of filing certified by the town clerk, shall be filed forthwith by the petitioner with the officer or board whose order or decision is being appealed and to the permit granting authority. So in other words, so you do have a form and that is what was filed with a February 14th date. You do have a form for that purpose, which spells out this procedure. So this letter, by the way, the letter that I have, my letter is dated December 13th, is addressed to John Allen. Does it, I don't see that it copies anyone. So as far as that goes, there are some informalities. So there are, I guess, really two questions. One is for the board. One is the manner in which the December letter was phrased, clearly a timely letter. And then the issue of whether the procedural requirements of the Zoning Act in Chapter 48, Section 15, whether they've been followed. Whether they were followed in December. They clearly were in February, early March.
Am I allowed to speak?
Well, sure.
Am I allowed to speak?
Yes, you are.
So here's the problem. The problem is because I was already outside the 30-day appeal window when I found out about it, I didn't know what to do. I know exactly what I'm supposed to do in the 30-day period where I have the ability to appeal. Once that 30-day period had expired, because it wasn't posted month after month after month, and I found out about it because someone was on my driveway, I didn't know what to do. The first thing I did was reach out to John Hanlon and Woody Chittick, the chair of this committee, and said, I am a citizen of the town of Cohasset. What do I do to need to appeal? And I did exactly what I was told. At this stage of the game, you need to do it as quickly as possible and hire a lawyer. And that's exactly what I did. But I didn't know. I've never done this before. I've never hired a lawyer for this before. As a citizen, I didn't intend to hire a lawyer to plead my case. But because the town didn't do their job, I'm now being penalized because the town never responded to the December 20th email. And they never responded to the 20th email. I sent that exact same thing to Woody as a backup. So it was sent to John Hanlon. It was sent to Woody. I did everything I was supposed to do. And then my lawyer tried to reach out, and you've got all the, I provided you all the timelines. I spent a lot of time on it. I spent a lot of money on my lawyer doing it. I don't know what I'm supposed to have done differently. This is all because the town didn't follow their own zoning bylaws that I'm now being penalized when the minute I found out, I told everybody that I was going to appeal it. Please tell me what to do. Now, I don't know what else I'm supposed to do as a citizen of the town of Cohasset. I have followed this. I've been to the planning board. I've provided, I mean, I have a case that was hoping that I was going to be able to show you, and I don't need to, I mean, but I've been involved in this from the beginning. I am representing all of my abutters, and they expected that I was, I mean, I don't know what else I could have done. I really, really don't. No one ever responded to the December
All right.
20th letter.
Let me ask Dave.
I'll note that there were 2 emails following that letter that went to Woody saying, you know, my lawyer filed a letter of appeal. And then another email saying, I never found out what happened to my letter of appeal. So I don't know exactly whether there are magic words, but it would seem to me that the town knew that there was an appeal of this building permit. And whether it was on any kind of a form or not on a form, we don't have a procedure for that I know of. But there's no question that within the 30 days after he found out about this, he took steps to get an appeal. He certainly took steps to notify us that an appeal was going to be filed, and made it clear that he thought an appeal was filed, and followed up on it to see what was going on with it, and got no response.
And didn't get an answer back.
Yeah. So I'm.
Yeah.
You know,
So one question too would
We
be,
do have somebody with a hand up. Adam Brodsky, your relationship to this?
Thank you, Mr. Chair. Good evening, everyone. I represent the property owner, the 792 Jerusalem Road Realty Trust, and may I be heard briefly?
Go ahead.
Thank you. I'm at something of a disadvantage since I was not provided with copies of the documents submitted. You'll recall that I, as a matter of courtesy, copied Mr. Honeywell's attorney on my submittal. But I think the board is missing a key point that was made clear by town council. There's a mandatory statutory procedure for filing an appeal. It's governed by General Laws, Chapter 48, Section 15, which says that the petitioner shall file the notice of appeal with the town clerk and then provide a copy then to the issuing authority. And so I don't doubt Mr. Honeywell's sincerity, but he asked the question, what was he supposed to do? He was actually supposed to follow the statute like any other citizen. And the failure to do so means that his appeal is not right, because you're required to file in accordance with the statute. Whether the town complied with, and it's not a zoning bylaw, it's a general bylaw, to publish building permits in the newspaper is an entirely separate issue. But that doesn't provide grounds or excuse an applicant from strictly complying with the statute. So a letter in December from Mr. Honeywell's attorney that they intend to file an appeal doesn't comply with the statute. The only letter that constitutes a formal appeal filed consistent with the statute was the letter, I think mistakenly dated February 14th, but actually filed with the town clerk on March 1. This appeal, despite Mr. Honeywell's best efforts and the board's sympathy towards those efforts, is simply untimely, doesn't follow the statutory procedure, and if you allow it to go forward, you will be violating the Zoning Act. I'm happy to address the merits of the appeal if you're going to get to it, but I think this is a crystal.
No, we're not going to get to it yet, Adam,
Thank
because
you.
if he doesn't have standing, there's no sense getting into the merits of the objection of the appeal.
I hired a lawyer, sent a letter as fast as humanly possible to appeal. I'm not a lawyer. I hired one because that's what I was told to do, and I filed an appeal on December 20th. It was
Right.
never responded to by the building department, and I forwarded the appeal to the chairman of the zoning board. And you can look at my timetable, which is what you asked for, and see how everything went. I don't know what else I was supposed to do. If you look at what my lawyer sent, he tried and tried and tried and tried. And you can see, if you read it, the 3 different times he went, he was told that somebody needed to be there in person, and then he was told somebody didn't, and then they were apologized because they were understaffed, and then they apologized because somebody quit. And it was one thing after another. I don't know how, with all that I've done from the very beginning, how we could get to this point when I have done everything I was told to do by my town.
Okay, let me hear from some other board members. Who would like to go? Lee?
I'm just concerned about the time gap, the December 2nd notice it's there. But if you follow, I believe the timeline, the attorney didn't try to file the appeal until February, sometime in February, which was clearly longer. And if it is, I haven't pulled up the exact law to file, but I mean, if it does say in the statute that it's filed with the town clerk, then the fact that they couldn't reach somebody in the building department, it should have been filed with the clerk's office. I just think that there's just too much time that's elapsed from the time that they were noticed and sent a letter and that they actually filed or attempted to file the appeal.
How about others? Matt, Mike, Charlie?
Yeah, I mean, I chimed in a little bit. I think, look, there's some lesson learned, I think, from the town here on process and procedure, but I think what we need to hone in on is, like if we look at this appeals form that we have, you file for a special permit, a variance, there's a spot on there for an appeal that they have signed here on February 14th, which is beyond the December 2nd date. I think if we get into, what constitutes, what kind of determines intent versus it actually happening, we kind of open up Pandora's box a little bit for future cases, and where somebody could say they sent an email and somebody was out of the office, and I'm not saying that happened in this case because I'm very empathetic reading the timeline of Mr. Honeywell with what kind of they went through, but I kind of think that filing an appeal means going in and filling out this application form where they checked off an appeal and brought their check and kind of put what their grievance was. And that looks like it's signed here on February 14th, which is,
Yeah, the tolling period ended January 2nd, roughly.
Right.
January 1st, whatever.
Yeah, I mean, so again, I think.
May
it
I
was-
interject?
No, not yet.
Sorry,
We
sorry.
want to hear from the other board members.
It seems to me that the equities are on Mr. Honeywell's side, but I'm not sure that the law is. And, I think town council's been pretty helpful with this.
Yeah, I don't think Mr. Honeywell, I don't think there's any more you could have done other than maybe have been familiar with a law that you probably had never read. You make the assumption if you hire a lawyer that the lawyer knows the law. And I think you were let down by your lawyer. I don't think there's much more you could have done as a non-practicing lawyer or citizen. Really, you hire somebody, you want to file an appeal, you assume they know the law, whatever that may be, and you assume they filed it. Now, I think the lawyer has a lot on his. Well, he's really the person who should have known better and didn't act. But I haven't. Mike, do you have any more? And Charlie, are you? I don't see your face, but Charlie Higginson, do you have a point of view on this?
I agree. The equity is on Mr. Honeywell's side, but the law says quite clearly 30 days and spells out how you filed an appeal, and that wasn't met. So if you're going to stick to the strict wording of the law, it was not filed in time.
Mike Dickey, do you agree with that or not?
Yeah, I mean, if the act says, here's how you file an appeal, you know, I hate to kind of assign blame, but I would think just out of belt and suspenders, you'd comply with what the act says you have to do to file an appeal within the 30 days. And, you know, obviously understand that because everything was so sideways already, that it might have been a bit of a morass to figure out what to do. And it sounds like Hollis tried to get folks to tell him what to do. But again, if it just seems to me that even if you don't know what to do, you go look at the act, and the act says, here's how you file the appeal, and you got to do it within 30 days. So you do it. So at least you can say, hey, I comply with the act's requirements in terms of filing the appeal. And again, that doesn't appear to have happened, at least not within the 30 days. And frankly, I think that's a shame.
Yeah, I do too. I think he was let down by the town as well as his own lawyer. But unfortunately, knowing Attorney Brodsky as I do, were we to say, well, what the heck, we'll kind of ignore Section 15 because Mr. Honeywell wasn't well treated, I'm afraid it might get thrown out on a procedural ground pretty quickly in court. Because the gap between December 2nd and February 14th is 2.5 months, roughly, not 30 days. I mean, if somebody had been sick or resigned in town hall, I'd give a pass for a week or so, you know, given the certain confusion and turmoil. But this is not a week or even 10 days. And with, you know, COVID and everything else, it's 2.5 months. Now, the lawyer should have known that. I can't imagine why he didn't. I mean, it's pretty basic stuff, but I can't get inside his head or anything else.
May I speak?
Sure.
When I found out that a building permit was issued, the first thing I did was went to the building department and spoke with John Hallen, the building inspector. I said to him at the time, what do I do? It was never posted. I never knew about this. I know that the Zoning Board of Appeals that has this email that I've referenced before that's in your packet that was never addressed. He did not tell me, he told me at the time, quote unquote, that town council had given him an opinion and therefore he'd issued a building permit and he was sorry and that he understood that I was upset that it was never posted, but there was nothing he could do. He did not tell me at the time, like he said in the last meeting, that I could write a 2-sentence appeal right there and then and write him a check. I asked him, what should I do? You did not post this anywhere. I did not have the normal 30-day appeal. What should I do? He told me, your ship is sunk. I reached out to you immediately and said, what do I do? You said, well, it was never posted. So what can you do? You need to hire a lawyer and do it. That's exactly what I did. I hired a lawyer and he sent a letter on December 20th that was never answered by the building department. And I CC'd you on the letter. I didn't know the wording of the letter. I'm not a lawyer. Everybody knew that I was appealing this and nobody answered. Then I reached out again and said, we've never heard back from the building department. What should I do? And you said, well, I don't know how you could be penalized for a non-response. I mean, it seems to me like everybody wants to get rid of this and they want to throw it in the dumpster. And what I'm telling the town right now is this is not a small matter. This is a public safety issue. This is a town liability issue, and it's not going away. And God forbid if something happens and the town gets sued because you've got a subdivision with a 15-foot drive with a 15-foot roadway that was allowed to happen right before your very eyes when nobody paid any attention to it. And now you're going to blast a driveway into the confluence of 3 common driveways. It's got a bus stop for kids at the bottom, and it's dangerous. Today, my mother asked me very nicely to drive her car down to the end of my driveway because the last 2 times she went down, she had to back up just to get out of her own driveway. It is not safe, and I am not going away. And it is not right that I'm being penalized by this committee because the town didn't do their job and post the building permit like they say they're going to in their bylaws. What am I supposed to do as a citizen? I hired a lawyer. He sent it within I did it as quickly as humanly possible. I didn't look at the wording of it. I forwarded it to the zoning commission. I heard nothing back from anybody. I stayed in front of it. I kept on top of it. You can look at my timeline, and he tried to deliver it 3 different times to the town. He was turned away 3 different times because no one was there.
Okay, but
and
that's not the fundamental issue, Hollis. Fundamental issue is by the time he wrote the appeal, 2.5 months had expired.
Right, because he tried to deliver it over and over and over again. And the town, I asked the building inspector and I said, if the building inspector had told me what he said at the last meeting, well, Mr. Honeywell, all you have to do is write 2 sentences right here in front of me and write a check. That's exactly what I would have done, but he didn't say that.
Okay,
I don't know, what am I supposed to do?
All right. Well,
I just don't know.
that's for us to decide. Somebody was speaking.
Yeah, just John Hallen. Anytime the applicant came into the building department for any information, this went on for several months, he was always given everything he asked for. When I told him when he came in, when the permit was issued, I said he could appeal. I don't know how to make it any clearer to it. You know, he was told who to talk to. It wasn't arbitrary or didn't treat him lightly. He doesn't look at the Mariner. He called me up before checking on the permits. Every time he called and asked about the permit, I would tell him it wasn't issued. It wasn't something that we were hiding or misrepresenting him. This was done in earnest, and we were clear to him from the beginning. Granted, there might have been some confusion that he thought that we would have to notify him. The portal had been up. I checked with the town IT people. They said it's been up and working since January 2019. I don't know what else to say. And again, anytime he was asked questions, they were answered in a prompt and appropriate way. We weren't hiding anything from him. So I just don't care to be misquoted. There was never a time that I didn't return his phone call or speak with him anytime he was in.
Okay, well, I think we understand what the issue is here. And the issue is December 2nd, he got his first adequate notice. December 2nd is the start date. And the issue is, was the appeal filed in a timely fashion, or was it simply an intention to file? And with sort of an open-ended end date. And I will suggest to the board that we, I don't know, I mean, I think we should deliberate after this hearing and maybe have the next hearing and then close it and deliberate.
Could I ask one more question of town council, Woody?
Sure.
Please? I just seems to me that, clearly, I don't think there's anybody on this call that doesn't think that, this could have been handled better and, there's blame on all sorts of different sides. But I'm just wondering from town council, does a body like the ZBA have the authority to exercise discretion and equity? Or are we kind of handcuffed to say, hey, at our level, the ZBA of Cohasset, we just tick boxes, and it's for a body higher than the ZBA of Cohasset to look at the equities and decide that, well, yeah, even though a box wasn't ticked, we feel that's allowable. That's really kind of what I'd like to know is, do we have any discretion here to exercise, or are we basically handcuffed by whatever boxes are ticked? They're ticked, and if a box is not ticked, then we have no choice. We have no discretion.
That's, excuse me, that's a fair question. And unfortunately, the answer is no. You don't have the ability to balance the equities, if you will. Your determination, as I mentioned a while ago, is to decide whether or not that mid-December letter was actually an appeal. And if you find that it was an appeal, then it's timely. If you file that it was not an appeal, I guess your question then is, well, it was not an appeal. It was a sign of a good intention, and all these other things happened, and there was some confusion and so forth. So no, the answer to your question is you could not do that. It's really yay or nay on that December letter, but it's a jurisdictional question, so you don't get into weighing the
I guess
equities.
there's another question beyond that. Let's say we decided it was an appeal, that it was a proper or properly worded appeal and had the effect of an appeal. The fact that it wasn't filed in accordance with the statute, is that fatal to it?
I guess at that point, we'd have to look at the facts. I'll give you one example. Anyone who files, not this kind of appeal, but a court appeal, let's say it's a zoning board decision or a planning board decision, whichever way it turns out, somebody files an appeal, an appeal in court. They have 20 days after the filing of the appeal. And that is strictly enforced by the courts. So there's this odd case where somebody goes to, and after you file the appeal, you have to then give, within the same 20-day period, you have to give notice to the city or town clerk that an appeal's been filed, whether it's in land court or superior court and so forth. So somebody goes ahead and files an appeal in a court, and then they write the letter to the town clerk. They come to town hall and hand deliver it. But actually, I can't remember if it's hand delivered or mailed to the town planner. The town planner is not the town clerk. The town planner very helpfully walks it down the hall to the town clerk. So the town clerk received it within 20 days. And the court found that even though the letter, let's say, was misaddressed to the town planner, the clerk did in fact receive it within the 20 days. So I'm recounting all of that because frankly, off the top of my head, that's the closest parallel I can think of. So I think that a court would enforce that strictly. And the question would then be, did it make its way to the town clerk within that 30-day appeal period? But I do think that because the statute says that the appeal has to be filed with the town clerk, I do think that that is a necessary prerequisite to meeting the jurisdictional requirements.
Thank you.
Okay, one last comment, Adam Brodsky.
Well, thank you, Mr. Chair. I'd ask the board to please deliberate and vote on this matter this evening. As I mentioned last week, there's a pending real estate transaction. The closing has been continued to address this appeal. And if there's any further delay, there's a risk that the real estate deal will be lost. So we'd ask that the board please act on this matter this evening and vote. Thank you, sir.
Okay. David McMorris, would you recommend that we deliberate now or have the second hearing and then do our deliberation?
We may as well wrap this up now, because otherwise people are gonna have to hang around for
Yeah.
2 hours to
That's
see what we do.
some of that same.
May I just speak one more time?
All right, make it brief.
The appeal was, I mean, the letter from my lawyer was sent to the town on the 20th of December. It was sent to you, Woody Chittick, on the 20th of December. Right now, what it looks like is the town chose to ignore it because the same way they didn't post the building permit in the first place. And so I can just get thrown in the dumpster. That's how this works. I can send a letter of appeal. You could see the letter of appeal. It's right there. I did both the timelines, mine and my lawyers. It's right in front of you. It was sent. It was forwarded to Woody. It was an intent to, it was an appeal. I didn't know what I, as a citizen, was supposed to do because the 30-day period went beyond because I was never notified. Now, additionally, I guess, I mean, if we're going to talk about timing, if you want to fault me on the timing of this issue, I remind you that a building permit only lasts for 6 months. This building permit expired 3 days ago. So how do you want to look at that? Maybe that's an unfortunate circumstance for the developers, the same way it's an unfortunate circumstance for me. So how do you want to reconcile that? As far as I'm concerned, the building permit's expired because they haven't broken ground in 60 days. I don't know if they have a buyer or not for this lot. That's just hearsay. I believe.
Okay, but we're not going to get into the merits.
Permit lasts for 6 months.
Well, I'll leave that up to the lawyers to decide whether, but what we have in front of us is this matter. And it's, I think, cut and dried. I feel sorry for you, but
It's cut and dry. You were sent a copy of the appeal and.
yeah,
a copy of
A,
the
I'm
appeal
not the
was
right
sent-
person, and B, my recommendation to you was immediately hire a lawyer.
That's what I did.
All right, and your lawyer failed to perform adequately, but I can't help that.
He sent a letter on the 20th of December. What else was he
I
supposed to
think,
do?
I think it's not helping to just keep going back and forth on this.
Yeah, no, we've heard the arguments and counter arguments. So I'd make a motion to close the hearing and immediately start to deliberate.
I'll second that.
Okay, moved and seconded. Woody Chidick, aye.
Dave McMorris, aye.
Michael
No,
Dickey,
it's
aye.
not.
Lee Darsai.
Matt Watkins, aye.
Did we hear from Charlie or not? I can't.
Yes,
Yeah, okay.
Charlie Higgins and I.
Yeah, there you go. Okay, so it's, the hearing is closed. I don't know if we need to do much more deliberation, but if somebody would like to present a counterpoint, but I will only say that what I've heard tonight says that an intention to file is not the same thing as filing.
I think even beyond that, Woody, I think if the letter had said, this is an appeal of the building permit for 10 Ocean Ledge, and it was sent to you or to the planning board or to anybody but the town clerk, we're still in the same situation. It wasn't filed properly under the statute. If it's not filed properly under the statute, it's not filed.
Yeah.
I believe it was sent to the town clerk. was it
Well,
not?
you're not allowed to speak anymore. We're in deliberation.
Can I speak? I
Yes.
just, while we've been on this, I Googled how to appeal a building permit. And within about 3 things, it came up directing you to the statute, outlining exactly what you need to do. I mean, it's, if someone had no idea what to do, it's simple to get guidance, just right from a quick search of how to do something. I just think, I agree with, I think everybody else that it's unfortunate, but that's what we have laws for, and that's what we have the timelines, and that Google has made it very easy for people to search for methods on their own.
And if there are other equities, as Dave pointed out 20 or 30 minutes ago, I'm sure the proper forum is the lower court, not this board.
Yeah.
So do I have a motion? Do we have a motion?
Yeah, Woody, I'll make-
I have
Okay.
one question.
Okay, Charlie.
John Helen, has 60 days passed since the building, six months passed since the building permit was issued?
After the last meeting, the permit holder came down and, as his right, extended the building permit for another 180 days because
Okay, so that solves that one.
so he has an active permit currently.
Thank you.
Okay, so do we have a motion?
Yeah, I'll make a motion to uphold the building inspector's issuance of a permit for 10 Ocean Ledge.
Well, the motion should probably be a denial of the appeal. That's what's before us.
Okay. So we'll make a motion to deny the appeal of a building permit, of the issuance of a building permit for 10 Ocean Ledge.
Okay, do we have a second?
A second.
Okay, moved and seconded. All in favor? Woody Chidick, aye.
Dave McMorris, aye.
Al Higginson, aye.
Lee Darst, aye.
Michael Dickey, regretfully, aye.
Yeah, yeah, I mean, it's really unfortunate, but. So the motion is approved unanimously to deny, approved, deny. The motion to deny the appeal has been voted unanimously. Okay. All right, why don't we move on to the next hearing? And the next hearing is 46 Border Street. And I guess Attorney Brodsky, you're representing the
Yes, Mr. Chair.
parties?
And hopefully you will allow Susan Hoadley and Karina Martinez to join, as well as Darren Grady from Grady Consulting.
I'm a little curious. A week and change ago, a week and a half ago, I requested some information that would, inform us, and we've received nothing back. Some, statistical information, like the kind of operations and things.
Well, thank you. We're prepared this evening to provide some of that information. We're working on it otherwise, but we have every intention of providing you with all of the information that you requested.
All right, well, because we don't have enough information to deal with tonight, you can give us a 5-minute overview, but I don't see any purpose in getting into any substance until we have an adequate and accurate application. And I would suggest to you, Adam, that the information is inadequate. And in fact, in some cases, the site plan and other things have some pretty glaring errors. And I would rather get into those when we have more information in hand. But you can give us an overview, but I don't know to what purpose.
Mr. Chair, respectfully, we submitted all of the information required to complete the application. You have asked us for additional information and to clarify what you've identified as potential inconsistencies. I am aware that there might be some slight differences in certain calculations between the architectural plans and the site plans, which we will revise. We didn't want to come back in with a full-blown set of revised site plans if we didn't know the universe of information that the board is looking for. And again, there's a fair amount of information that's been presented, which we would like an opportunity to discuss. We have every expectation of answering all of your questions, but if you give us the opportunity to at least explain to you what we're trying to do and the information that we provided, that might help clarify things.
Right? All right, go ahead, but let's make it brief, because I, for one, do not have enough information to deal with parking. I'm puzzled why you aren't applying for a variance and not a special permit. And as I say, there are some, I think, errors, but until we have site plan errors, for sure, I'm almost positive there's site plan errors. But I don't have enough
Yes, sir.
information to go on. I mean,
I'm
you can
prepared
talk
to
conceptually, but
Thank you, sir. I'm prepared to speak to the issue of parking and the relief that we're seeking. And I'm happy to have that conversation with you. And we are going to provide you with additional parking information to substantiate our request for a special permit. It's complicated. You did ask us some very good questions that we're trying to provide thoughtful responses to. As you can appreciate, Darren and Susan are very much in demand. And we're trying our very best to be responsive given their time constraints. But with that said, if I may proceed, I'd like to just provide a quick overview and then turn the matter over to Darren to discuss the site plan and then to Susan to discuss the architecturals.
all right.
Thank you, sir. And good evening, everyone. My name is Adam Brossi, and I represent Co-Lobster LLC, which is the applicant. Tom Sullivan is the manager of the LLC. I'm just going to briefly introduce the team, most of whom I've already introduced. Eamon O'Mara is our project manager with Harbinger Development. Eamon is in the audience and is available to speak. Susan Hoadley and Karina Martinez are architects. Darren Grady from Grady Consultants is our professional engineer, and Paul Mirabito is our professional land surveyor. And as you likely know, we're proposing to reconfigure and improve the existing Atlantica restaurant and function building. I'm not going to describe the site. You know it very well. It's located within the Waterfront Business District and within the Floodplain and Watershed Protection District. The existing building was constructed based upon town records in 1948. The lot is conforming, but not surprisingly, the building is not. It's non-conforming with respect to front, side, and rear setbacks, and the parking is non-conforming. We're proposing to improve the building to accommodate a smaller fine dining restaurant, a second smaller restaurant coffee shop, a small ice cream store, a small bakery, and a lobster pound. We're proposing to relocate the lobster pound from 82 Border Street to this location. And by reconfiguring the building, we're going to be opening up some new public areas. In total, we're substantially reducing the restaurant from the existing use. I think the present Atlantica restaurant has an occupancy load of in excess of 400 people. If you combine all of the restaurant uses we're proposing, it's approximately 272 people. And as I mentioned, presently, if you wanted to look at the harbor, you'd have the patron of the restaurant walk through the restaurant and you'd get a glimpse of the harbor from the back of the building. We're proposing to create an open area, public access that would afford people the ability to walk through the reconfigured building and enjoy the harbor from the rear. With respect to parking, and we'll talk about that at some length later, we believe the proposed uses are less intensive than the existing restaurant function use. The existing restaurant, we understand, was required to have 74 parking spaces. What presently exists on the site are 52 irregularly shaped parking spaces that don't conform to your parking dimensions. We're proposing to improve the parking lot to provide conforming size spaces, conforming drive aisle, and landscaping where none exists. The proposed uses under your current zoning bylaw require 46 parking spaces, and we're providing 28 on site, which we believe will be sufficient for the different uses which have different times of operation, as we're prepared to explain. I just want to be clear, because I think there was a misunderstanding when we were in front of the Conservation Commission. We're not counting any of the parking spaces that are shown in the street layout. After consultation with the town, we were simply asked to show what could possibly be done on the street if the town endeavored to provide additional parking. And we did that for illustrative purposes. We're not counting any of those parking spaces. The 28 parking spaces are located entirely on site. Just quickly, the proposed improvements are not going to result in a substantial improvement under the state building code. And so we do not need to conform to current floodplain hazard requirements. And quickly, we need a special permit for the restaurant and retail uses within the waterfront business district. I've included a request for a special permit to alter the non-conforming building, although the specific changes that we're making are not within the non-conforming sections of the building. All of those changes are outside of the non-conforming setbacks, but in an abundance of caution, I included that relief. I included a special permit for altering the non-conforming parking, because we're going from one non-conforming parking use to another non-conforming.
No, I don't think that's true, Adam.
And happy to answer that. And a special permit, obviously, for alteration of the building within the floodplain district. So, Mr. Chick, I'm happy to discuss that issue with you
No,
now.
I'm
Would
just,
like to
I'm
hear
just
from-
curious about why you're not applying for variance, or do what the Atlantic and Salt House have. I'm eager to see your valet parking plan.
Yes, sir. So just to briefly answer your question, it's very similar to what we did on South Main Street, where we had a non-conforming use and non-conforming parking. We were able to achieve a change in that non-conforming use and the change in the non-conforming use via a special permit, because parking is deemed to be a use under the Cohasset zoning bylaw. And so we use that model for coming forward with yet another request for a special permit. I do not believe that we require a variance, but of course, we're happy to discuss that with you further.
Yeah, I don't want to get into it tonight, but
Yes, sir.
of course, the Atlantica Restaurant and Salt House each each needed a special permit and not a variance because they fully complied with parking
So,
via
Mr. Chair,
valet overflow. Now, if you have a valet parking plan, free valet during all hours of operation, the way those two restaurants did, I'm all ears, and that's a special permit request. But if
So,
you don't
Mr.
have a
Chair,
valet parking plan and you're coming in with an parking that does not meet the bylaws, that's a variance. In
So,
my
Mr.
estimation.
Chair, I'm sorry, sir. Forgive
No,
me.
that's it.
Just to be clear, I don't represent the old Salt House in connection with
Of course
this
not.
matter.
Yeah.
It's a separate property. With respect to, and if you have issues with respect to the old Salt House, it's for another time and place. But I researched as best I could the title and the town files with respect to the Atlantica Restaurant, formerly, I guess, Hugo's back in the day.
Mhm.
I could find no special permit or authorization of the restaurant use or the parking. I think the conditions of valet parking that you're talking about related to the improvement of the old Salt House in 2000. I do know that these properties have been held in common ownership by various parties over the year and have been jumbled together. But at the present time, obviously, Co Lobster LLC owns 46. The old Salt House is owned by others. And I'm simply not aware of any special permit relating to the actual Atlantica restaurant use, which is why I suggest that it's a non-conforming use that goes back to the construction of the restaurant pre-zoning in Cohasset and has been continued.
Okay, well, we can
going
get into
forward.
that in another hearing.
Yes, sir. So with that, could I ask Darren to please take you through the site plan? I think he might be able to clarify some of the questions that you had raised. Thank you.
Can I share my screen? Can you hear me?
Yeah, sure.
Okay.
You able to share your screen, Darren?
Yes, here we go. Thank you.
You're welcome.
Good evening. My name is Darren Grady from Grady Consulting. The plan before you right now is the existing addition sheet. The submittal that was provided to the ZBA. This one's revised April 6, 2022. The existing property has frontage along Border Street, shown where my cursor is here. It comes down to property line here, down to mean low water. The area of the lot is 65,200 square feet. The back line follows mean low water back to this property line that bisects the old salt house from the old Atlantica. The setbacks aren't conforming because we have 0 setback between the two buildings. We have a 1.2 foot setback from the building to the rear line here. And currently we have a 13.3 feet setback from this portion of the building to the front lot line. We are showing 52 parking spaces here. Those parking spaces were striped on site and off site, and they consist of these here, 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 as well as these ones over here. 36 of them are within the lot line. There's various landscaping throughout the existing site, a little bit in the monument here and along the building here. We're proposing changes to the parking lot. 28 proposed spaces, including 2 handicap spaces shown here. We're proposing landscape improvements. This entire island would be landscaped. Also, 3 lights would be constructed here too. One here, and one here. A walkway will be constructed here of recycled brick, seashells, recycled brick, and seashells. There'll be a bike rack here and also a car charging station here. The utilities on site. There's existing water, electric, sewer. They'll remain as existing, and as well as drainage. There'll be no proposed changes to those. For the building improvements, I'll turn it over to Susan to discuss those.
Yeah, why don't you look at and evaluate numbers 27 and 28. I think as drawn, they're undersized.
These meet the handicap space requirements. They're probably 8 feet wide with an 8-foot space between them.
So they're going to share an exit, or, okay, if that meets code, fine.
I'll turn it over to you, Susan.
And you've in no way have you impeded or interfered with access to the salt house? In this
No.
design?
So our improvements here are basically removing pavement to form this landscaping. We are improving the fence around the dumpsters, but we are maintaining their loading space here. And we have no improvements down over here. Access is the same access as it currently is. And we're not impeding on the access here.
And it looks like your existing condition now, right, has where the landscape would be, has like 5 or 6 spots that are presumably used by residents via some sort of agreement.
These here,
Those belong to the Salt House.
No, the ones that are, currently just outside of the temporary construction fence would be more in the area, I think, where you have the proposed landscaping.
so you're looking at,
Where the cursor is right now? Matt?
Um,
I can zoom up if you, or move to where, if you assist me.
yeah, I'm just looking at my plan here, nearby the stone tower.
Stone Tower is here.
Okay, yeah, and right along the edge of Border Street now, I think you have like a temporary construction fence that has, like 6 spots that are being utilized by homes across the street. I just didn't know if, if those 6 spaces, if there's, like we've seen spaces in Town Hall, for example, that are deeded to different people at different times of day. I didn't know what the agreement was with those 6 spaces that exist on that outer edge.
I didn't see any agreements in the deed that that was for Co-Lobster. Did you, Adam?
No, Mr. Watkins, we're not aware of any access or easement agreement with residents. I don't know if that was a courtesy that was provided by the prior owners.
Okay. Yeah, just a question that jumped out at me. I drive by it a lot, and it's currently notched. The fence is notched in, and there's maybe 6 or so spots. It has been like that for a while. But
Okay.
thank you.
Would you like me to turn it over to Susan for some discussion or a description of the building changes?
Sure.
Okay. Let's go to EX 101. Okay, we'll just start. Once we get screen sharing up, we will start. Good. We're getting there. Okay. We'll start on EX 101. Good evening, members of the board. My name is Susan Hoadley, and I'm here with Karina Martinez on deck. We are from Hoadley Martinez Architects. And what I'd like to do is just be as brief as possible and give you an overview on everything we've done so far. I'd like to also thank you for the clarification request, which we responded to. We picked up the comments requesting additional dimensions on the existing conditions and provided some more metrics. So if there are more required after tonight, we'd be happy to consider those as well. But let's start with EX 101, which is the main floor of the existing building as we all know it. It's a large single-purpose event space that really has 2 settings. It's able to accommodate at-capacity crowds, or it sits dark and empty. It's got 1 point of entry, which is locked most of the time and precludes any sort of casual public use of the entire edge of the rest of the complex to the water. And what we're proposing hopes to alleviate that and give something to the community that's pretty special. On the existing,
You're talking Susan, about the present condition under the new ownership. You're not talking about the way this building was being used 2, 3, 4 years ago.
That's correct. I'm talking about the present condition of the
Okay,
building.
well, I mean, if the owners have opted to darken and lock the doors. That is not the way Atlantica has historically been operated.
No, you are correct about that. It is the present condition that we have been documenting. So again, one point of public entry, the way that the complex is configured. There's no access to the water beyond the parking lot, and no public accommodation or access at most times. And we think that the plan that we are proposing, even in this conceptual state, clearly shows that we've addressed each one of those points. Here's the second floor of the Atlantica complex, which not too many people probably know about. It's a rabbit warren of borrowed space, which has been adaptively reused over time for the single purpose of wedding prep. It forced a lot of the mechanical that was in that attic out onto the roof where you see it now. And we'll show you where the mechanical currently sits on top of the roof here. Our intention is to reuse that second floor both as a grander double height space for the main dining room below, and to reuse that space so that we don't have to continue to litter the roof with mechanical to the best of our ability. So let's go, now that we've seen the existing, let's go to what we're proposing. AS 101 shows the proposed conceptual layout of Cohasset Wharf. We think of it as smaller, better spaces that respond more to the grain of the Tower Wharf, the historic Tower Wharf configuration of several buildings on the site instead of one megalith like there is now. And what we're proposing here is pretty simple. The orange areas show public outdoor access areas that start at what is now the closed door, go down a new open air walkway out into a covered space, which would serve the restaurant and other uses in beautiful weather, and then out to the existing dockway, as you see it in the plan in orange. The yellow areas are small retail shops. This one, the bakery, and then the Lobster Pound and probably an ice cream shop or something else in that area. And the blue or the purplish is food and dining. The space that we all know with grand fireplace would stay fine dining, served by the kitchen in gray, and restrooms that serve the restaurant. And then when you go back down to the other side, you see a coffee shop with a prep kitchen and proximity to a public bathroom, which is just the renovated bathrooms that we're all familiar with from Atlantica right now will now become usable by the public at large. And the roof plan is not as schematic and easy to read in nature, but essentially the added areas are a signal cupola in the front. We're going to keep the faceted sort of lighthouse form that is right adjacent to it, and you can see in the elevation how that ends up looking. We are going to add a new gable roof into the coffee shop here. And then we are also proposing to add a porch roof and a new gable on the existing roof that attaches to the salt house. We'll show you in elevation what that looks like. Going back to the restaurant, a new proposed roof that marks the entry to the restaurant to the rear at the end of the walkway, and 2 to 4 new proposed dormer roofs that let light into the new double height space in the new restaurant area. Next. And here are the elevations. These, the way we've drawn them, they're sort of before and after. The drawing at the top is the existing Atlantica building, and the one at the bottom is our proposal. And if we go from left,
Wouldn't it
Starting
be
at
the other
the-
way around?
excuse me?
Those, wouldn't it be the other way around? The one at the bottom is the existing and the one at the top is proposed?
The one at the top is the existing elevation that you see when you drive up to the complex from Border Street.
Oh, I'm sorry. Okay.
And the
yes.
proposed is below
Got
it. Mhm.
Yeah,
Yeah, so this,
I was
this is,
thinking
a-
of it.
okay.
Yeah.
So this is what we're essentially doing. We're not adding. We're reducing the entire footprint by 35%, and we are adding some very definitive points of interest in the cupolas in the front and at the end of the walkway. Further, we're giving a more what I'll call a wharf-like scale to the primary the primary building that's here. I'm going to just I'll grab the mouse and do it. This one, this is the lobster pound. It's served by a loading area here. And this becomes an inviting walkway to walk down up a ramp, which is both handicap accessible and we think very inviting, ending in a restaurant edifice at the end. We're keeping this small vestige of the Hugo's Lighthouse, and we're also keeping the porthole windows from Atlantica. Here we're proposing to put some sort of a community bulletin board or map. In this area, we could put the station for the Captain's Walk that's being developed by the historical folks in this area that describes what Tower Wharf was. And then on this end, we have a very open, welcoming edifice that welcomes you into the coffee shop. This is the east elevation. Again, before on top, after on the bottom. What we're proposing to do is fairly simple. We are proposing to add, this is the side of that, that sort of marker cupola that we were talking about. And this is the side of the marker cupola that marks the restaurant. We are going to replace the plate glass windows with operable windows so that the building is both more sustainable and more pleasant to be in when you have ocean breezes to open it up to. And so we're proposing 2x2s that have an awning leaf on top to fill up those big plate glass areas. And though that would occur along the coffee shop and then again, all around the outside of the restaurant. This is completely open air area in here. Okay, let's go to the next one. I just want to move through this quickly. There's a lot to say.
Yeah, but we're not
This
going
is
to be debating this tonight. We're just getting an overview.
Sure, good, good. So we're on the north now, we're on the water side. And this is what you would see. Right now, it's a big expanse of plate glass, essentially. And what we would be proposing is to replace that solid expanse of plate glass with an open area with traditional railings that that can serve the inside of the restaurant, again, in beautiful weather. And this would be the new edifice to the harbor that you see right here. And again, Old Salt House remains over on the western side. When we come around to the west from the, what I'll think of as the Old Salt House side as you come down Border Street, what used to be a pretty big, this, a monolith with plate glass windows will remain somewhat the same, inserted with these new mullioned grilled windows. And again, 1 or 2 eyebrow windows on the top to let good light down into that new double height space. And this is an interesting elevation. This is actually a section in an elevation cut right down the middle of that new walkthrough. So if someone were to come in here from the parking lot, they'd go right up this ramp, go past this new porch. This door goes up to the 2nd floor and is additional access. When you come down here, there'll be an opportunity for a big graphic here. We were thinking that the tower map, that fantastic huge document that's in the Historical Society, could be interesting as a replica here, as a place where people gather before they go into the restaurant. Here, looking the other way, becomes an east elevation, and this becomes the corner of the iconic cupola, and then the walkway in with the covered wharf beyond with a view out to water. Here will give everyone in the public a new opportunity to enjoy the water out beyond the restaurant area. Okay. Okay, do you want to switch?
I've got some questions about AS 101 or whatever your color coded floor plan.
Okay, do you want to do that?
Just roughly. I mean, so I understand it. The plan that I'd seen before had a restaurant in the Lobster Pound, some sort of food service. It seems to. Am I correct in saying that's gone away? There will be no food served there.
There's an ice
pound. Lobster pound.
Right. There's a Lobster Pound there, but there's ice cream shop sign.
No, I'm talking about the Lobster Pound.
Okay. Yes, that would be that would be. I think that the developer can speak more articulately to what's actually being envisioned for that space, but it is
well, we
being
can
seen as
come at it. Adam, make a note. If there's going to be food served there, there's going to be parking required at a different calculus than just a Lobster Pound. Okay, now,
Mr. Chittick, I believe we did account for takeout food service with a restaurant style parking. I'll have to double check.
Right.
But one of the things that we need to talk about is the parking for the restaurant use, because we did consult with the building commissioner regarding the various uses, and we got instructions from the building commissioner how to address parking. And because
let me cut to the chase, Adam. It's one space for every 3 seats. It's not 200 square feet. It's not even 100 square feet. That's the way this board has dealt with restaurants in the past, going back to 1990. And I doubt it. I mean, I'll leave it up to my colleagues. I doubt that we're going to change it because it's a zoning board decision.
Thank you, Mr. Chick. Again, we, anticipating the parking questions, consulted with the building commissioner, who gave us his opinion as to how we should address that parking.
Great.
And we used all of those numbers for our calculations.
Okay, as long as they comply with what the bylaw says, 1 space for every 3 seats, you're fine.
No, sir, then I'm not being clear. Specifically, we're told that we should calculate this as 1 parking space per 200 square feet of net floor area.
I doubt that's going to fly, Adam. I mean, you can do it both ways, but I doubt that 1 space for every 200 feet would be accepted by the board, I'm guessing.
No, thank you. This is important, but I just want the board to understand, as I would any other project, we would go speak to the building commissioner as what he would require when there are any questions of his uses, because in the first instance, obviously, it's the building commissioner's.
Well, the building commissioner is very competent, and he deals with occupancy permits. We're not dealing with occupancy here. It's a very different calculation. But we're not going to argue it now, but I'm just telling you where I think it's going to end up. Let me ask a second question. The shop, which is a bakery, will there be food served there? Or is it a strictly takeout?
No,
Will
there
there
will
be
be
any
food.
chairs seating?
There will be food served, and again, we calculated that use consistent with the advice that we were provided.
Okay, well, I would recalculate it because we'll probably want to see it both ways. Thirdly, the covered wharf, will there be any seats there?
We're not proposing any specific uses within that covered wharf. In the future, if again, the project is constructed and operations are successful and we are managing parking, we want to reserve the opportunity to come back to the board to seek an amendment of whatever relief may be granted, but we're not proposing, for example, restaurant tables at the present time within the covered wharf.
Or if I go to the bakery shop, there wouldn't be a bench. I would sit and eat my food.
There's seating proposed for within the bakery shop. So
Within
again,
the bakery shop, right?
Yes,
But-
sir.
But not no seating in the covered wharf. So you'd be willing to accept that as a condition.
Yes, sir. No, we're not proposing any specific restaurant uses within that public open space area.
Okay, all right. Okay, and there is, well, all right, you know what I want to see in the lobster pound. I want to see how much food service there will be there as well in the seating. So I want to see seating both in lobster pound as well as the bakery.
I'm sorry, I was muted when I was trying to answer that question before. The Woody, it's my understanding that the lobster pound is all retail, that it doesn't have any eat in or
Okay, yeah,
cafe.
no, my comment was on an earlier plan, it was, it had the legend restaurant.
Oh, okay.
And I didn't know, and I suspect that's been removed as a consideration, but I wanted to confirm it.
I included it on my plan as far as the site plan. I will change that. I wanted to document the way I was calculating parking.
Okay.
Okay.
Are any questions the board has at this point? I'm waiting to see, for instance, the square footage of the cafe and seating arrangements there. Looks open, blank, but clearly prep kitchens and things have a different parking requirement than do sit-down restaurants. So I'm just, when we get the more specifics. And Adam, you ought to calculate the parking both ways. Because the board might opt for one space for every 200 square feet. I'm of a different opinion, but that doesn't mean I'll prevail. However, I would suggest to you that if you go back into the earlier approvals, and a good case in point is Salt House, we use one space for every 3 seats. Plus the bench.
Thank you, Mr. Chittick. I'm listening and taking notes. At an appropriate time, I would like to review the hours of operation with the board because
Right.
that affects our parking demand study. And so we do have proposed hours. I've been torturing Darren on this issue, and it would be very helpful if we could clarify the hours. We based hours upon some existing uses of which we're aware of in the town. But if you'll tell me when the appropriate time is, I don't want to take this out of turn.
Okay. Maybe when we reconvene in May, one of the first things, besides the statistical filling in the gaps, you should be prepared to deal with the special permit. This is, in my estimation, again, without having heard a lot of back and forth. It's a different use. It could be even considered a more intense use certain times of day than the Atlantica restaurant. And as I say, the Atlantica has historically provided offsite, but on property they own or did own, valet parking. Valet parking was critical to calculating the capacity, the allowed capacity of the salt house. And it was critical for Atlantica's operation. Valet parking probably has gone away. So to my mind, where a couple of years ago, there was adequate overflow parking, there now is no overflow parking. And
Yes, sir.
we'll just have to
We're-
take a look at it.
We're acutely aware of, again, I don't have the breadth of, or the historic knowledge of these sites as do many members of the board. I'm relying upon the information that's been publicly available to me, the registry records as well as the town records. If there's any additional information regarding the permitting for the Atlantica restaurant that I'm not aware of, if the board would be so kind as to either point me in the right direction or give me that information. Again, the valet parking, I believe, was associated with the old salt house, but I'm
Actually, not so. It was really much more of an Atlantica thing. They always had the 2 to 3 valet drivers out front. They had a keyboard where your keys were hung. That's very traditional. I don't know if they had a special permit for that or not, but they were complying with parking as best the town understood it.
and that may be an operational issue that they decided upon. I'm just trying to understand what the legal parameters are and what was
Yeah, I
required.
don't, also, you can address the issue of pre-existing or grandfathering. I think with a new use, a new configuration, and a non-transferable special permit, you're gonna have to comply with the bylaws as they are.
Thank you, Mr. Chick. Again, I'm not aware of a special permit for Atlantica, but if there's one, the board, if you'd be so kind as to let me know. And we believe these are, if not, they're fundamentally restaurant use to restaurant use with a few little twists. So it's not we didn't see this as a change in use because the parking is presently used for the restaurant function. And we have the candidly the opposite view of the world, which is that at 6:30 on a Saturday, if you have a 400-person wedding, you have all of this traffic presently coming to the facility and looking for parking, whereas we're proposing different uses that would be open at different times of the day. And we believe that this is far less intensive during those peak periods.
Yeah.
But
Well,
again,
when we have operating hours and things of that sort, I think it'll shed some light on it. Right now, we can't deal with it.
yes, sir. And I
know,
do
it's
have, I have that information, which I just wanted to confirm whether it was reasonable so that we can use that for our assumptions for our parking demands.
Sure. Well, we have time.
Well, thank you. So if I can just take 2 minutes, we're proposing the ice cream shop hours during the weekday between 11 a.m. and 9 p.m. and on weekends, 11 a.m. to 10 p.m. The coffee shop would be 6:30 a.m. to 2 p.m. during weekdays, and on weekends, 7 a.m. to 2 p.m. The bakery is proposed during the weekdays, 7 a.m. to 3 p.m. and on weekends, 7 a.m. to 5 p.m. The restaurant proposed 11 a.m. to 9 p.m. during the weekday, and on weekends, 11 a.m. to 10 p.m. And the Lobster Pound is proposed to be 11 a.m. to 9 p.m. on weekdays and 11 a.m. to 10 p.m. on weekends. And those are based upon, we believe, the hours of existing businesses within the area. But we just wanted to review those with the board to see whether the board had any particular concerns that we could then take into consideration.
No, I don't know. It's just a question of load, as you say, and timing of the day.
Yes, sir. So I'm not sure whether Susan finished her presentation. I commanded the stage. Susan, are you done?
I was almost done, but one more sheet I had was, do you want to go to the end of the elevations? So I brought you through the elevations. Okay, and then the next one was a June sheet. Okay. All right. So this is I think that these two drawings really do tell the story of the way that the building sits on the site, its height, scale, and mass, and hopefully tells the tale of how we've made, we've broken things down into a sort of a much more a much more manageable and more wharf-like scale, and are arguably returning it to a style that is hopefully compatible with the architecture of the harbor. So that's it. Thank you.
So board, questions that they can address now as opposed to when we get another look at capacities and available spaces and things of that sort.
I have a
Go ahead, Lee.
I have a question. I mean, there's, 28 spaces, but where do you think that people are really going to park? All of these businesses overlap for approximately 4 hours a day. Where do you envision that there's going to be parking on side streets? Or, I mean, there's not enough. The parking spots aren't enough for all the people that in all the spaces that you have. I mean, all the businesses that you have.
Ms. Darst, this is Adam Brodsky. It's our burden to demonstrate to you that at peak times that we will have sufficient parking for those uses. So I'm going to defer answering that question and come back with additional information to the board. I do note that there's other public parking in the area, but we're not counting on any of the other public parking in order to satisfy our parking demands.
Okay, we'll look forward to that then.
Dave,
No questions at this point.
Matt,
No, I don't have any additional ones. Adam, the question I asked earlier just about those reserved ones, but my only purpose of asking it was to ensure that of the spaces that you are proposing, in other words, there aren't 5 or 6 of them that are spoken for at different hours of the day by others. So if there is any clarification on that.
Mr. Watkins, thank you again. I'm not aware of any formal agreement. I know that this site has had lots of past practices. Obviously, circumstances have changed with the sale of the property. It's no longer in common ownership with other properties. And so we're going to have to work cooperatively, obviously, with the town and the neighborhood to address this. But unfortunately, I'm not aware of any formal agreements with respect to use of those spaces by any others.
Okay.
are
Yeah,
they?
no, otherwise, I think, obviously our issue stems with parking. I think your plans are, sharp looking plans and obviously bring some vibrancy to the area. We just need to find a way within the bylaws to get behind that. So I look forward to the future presentations.
So we agree wholeheartedly. We understand what we need to demonstrate to the board so that it's satisfied.
Just a small point, there's below the Salt House is I get people to call it a docominium. There are privately owned spaces there. Does parking come with them? And my understanding was there was parking across the street for those boat owners, but I don't know if that's deeded or not.
So Mr. Chittick, the documiniums are a condominium unit associated with the old Salt House Wharf. And so I have no information regarding their parking requirements. A small portion.
Okay, but none of your parking intrudes on whatever parking they use. I just want to be sure we're double counting.
I don't know what parking is associated with the documinium, which is on the other property. So I don't know how to answer that question. But we're not accounting for any parking on 46 for the documinium, which is located on 44.
Okay. Charlie Higginson, I haven't heard from you.
Yeah, I noticed the towers are 36 feet, which is higher than our height restriction, but with an exception if it's less than 5% of your area. How are you figuring that?
Okay. Okay. Okay, this is Susan. So if you look at the east elevation, Mr. Higginson, on the screen I have, where the mouse is, you'll see that from the median grade to the midpoint of the roof is 32 feet. The mid slope here, which is at 36 feet too, is that?
Yes.
That's above sea level. I was doing my calculation from the midpoints of the corners of the building.
Gotcha. Second question, Adam, you mentioned there'll be no restaurant or seating facilities on the wharf. That means there'll be no chairs or tables?
I don't know the answer to that question, Mr. Higginson. We would not be able to use that for restaurant seating. I will ask the owners what they intend to do with that wharf.
And finally, a very attractive part is the wharf and accommodation for boats. But to my knowledge, the inside of that wharf, there would be about 6 inches at low tide, and not a very big boat could dock there. And on the outside, if they're pointed in, are they getting into the harbor channel?
So, Mr. Higgins, the wharf is not intended for dockage. It's merely to be public open space to allow people to walk through the center to be able to view the harbor. There is a float that's licensed for the property. That's not part of this project. It's subject to a separate waterways license and other permits. So but we're not proposing to bring vessels up against the proposed covered wharf and dock vessels there.
Because the site plan has boats there.
No, so that's the existing license float associated with the property just for display purposes. It's not part of this proposal. And I don't know whether it's been deployed in recent years, but there's a license for a gangway and a float for this property. And that's what was depicted on the plan simply for informational purposes.
Thank you.
Yes, sir.
Board have any other questions? Cassandra, there may be a lot of interested people in the audience. I would hasten to say that we're at the very early stage here with more questions than answers. But is there somebody another representative of a group, a civic or other board that would like to speak?
Sure. So I was going to ask Attorney Brodsky, there's a Thomas Sullivan who has his hand raised. Is that the property owner?
That is correct.
Okay, so I'm gonna pull him forward and make him a panelist because it seems like he may have something to say. There is also a question in the Q&A as well. While he's being pulled forward as a panelist. So the question is from Phil Cantillion asking, how have they calculated employee parking during hours of operation?
Thank you, Mr. Chegg. It's Adam Brodsky. That was a question that you posed or whomever prepared the spreadsheet for us that we needed to consult with the building commissioner because it's interesting, under the zoning bylaw, there are specific employee parking requirements for specific uses. But the uses that were proposed here do not have a specific employee parking requirement. And so the assumption is either that the parking requirements for example, restaurant use included employee parking, or there's another provision of the zoning bylaw I'm not familiar with that requires employee parking. And we need to consult with the building commissioner regarding that issue.
The answer is that there is, that the bylaw under E, subsection E, is silent on employee parking for restaurants. Strangely, we're an outlier among any towns I've looked at, other bylaws, but that doesn't mean that we wouldn't consider a modification and to accommodate to add parking for employees. Heretofore, employees have parked over on Elm Street and walked the 800 feet or whatever it is back. But that was then, and this is now. I don't know. We'll have to, this is part of our due diligence.
Yes, sir. It's a complicated issue. This is a dramatic change in how the properties have been operated, and we understand that. And so we're prepared to work with the board to address those issues.
Okay, does Mr. Sullivan wish to add something?
Hello? You hear me?
Yes.
Oh, okay. Yeah, introduce yourself, please.
Hi, Tom Sullivan. I just wanted to answer the question on the space that's cut out in the fence there. There's no agreement on that. The people were using it from across the street, so I told them I'd leave it cut out for now. I think they're building a driveway over on their property, but there's no agreement for that long term. They didn't even ask for it. I just left it open for them. And the dock, which was there till last year, it just stays the same. We're not doing anything with that. It was in use last year, probably not this year, because the only way to get through it is through the restaurant. So it's not really accessible any other way. So, but it'll be nothing new there. The rendering doesn't show it exactly how it is, but it was up there till last year. It'll be the same.
Okay.
Adam, I have one last question for you. I'm a little puzzled. Do you need a site plan review by the planning board?
Mr. Chadick, yes, and we applied for site plan review.
And commonly, the site plan review is conducted and then the zoning board meets. We typically do not meet before the planning board has considered a site plan or whatever. Why the sequence of events?
The desire is to begin the project as soon as we possibly could because no one wants to see this building closed down. So we were asked to expedite this process. And again, we discussed this with the town as to how we should proceed. I should add that we also need to make sure that our uses are permissible here, which would be the basis for site plan review, because the restaurant and retail uses need to be specifically approved by the zoning board within the waterfront district. So these are not allowed as of right. And so we need some indication from the board that they're okay with these uses, which would be the basis for then proceeding with site plan review. But we filed everything together in the hopes that we could shorten the permitting period and expedite the process so that we can bring this project to life and back online.
I just wouldn't want any well-considered changes, small or large, to drive, I'll hang on parking, but uses or anything else, and then we'd have to reopen a hearing to consider changes that another board is appropriately made. It's usually a lot more expeditious to let the other boards proceed.
Mr. Chair, we had no expectation that the zoning board was going to close the public hearing and vote on this project without both the planning board and the conservation commission weighing in.
Yeah, okay. So
I
we
have
will
another question.
go.
The proposed dumpster next to on the east side of the building, how do you get to it? Seems to me you run over the bicycle rack.
That area in there is just a trash handling area, so there'll be bins to roll out of there. It won't be a physical dumpster as far as you need to get a dump truck in there. So yeah, you'll be wheeling that out by a cart.
Oh, it's there, not where the arrow goes. Oh, I see. It goes all the way over to there. Fine.
Mr. Higginson, there is a dumpster on the other side, I believe, of the building.
Yes, I know that one.
Okay, any other comments from the board, or should we continue the hearing? Well, I'd make a motion to continue the hearing until, Sandra, May 3rd, is it?
Yes, that's correct.
It's what?
Yes, May 3rd.
May 3rd. Okay, I'd make a motion to continue this hearing till May 3rd.
Second,
Seconded. All in favor, Woody Chidick, aye?
Dave McMorris, aye.
Charlie Higginson, aye.
Michael Dickey, aye.
Matt Watkins, aye.
Okay,
Lee Darst, aye.
all right.
Thank you, everyone, for your patience.
Thank you.
Okay,
Good night.
Thank you.
good night. So those hearings have been continued. There's kind of a small point. I don't know if it's small or not. If you look at the Salt House special permit, which was granted in 2000 and appealed and, confirmed in 2003 and appealed, that special permit for the Salt House expires with the change of control. It's not transferable to another owner. And so for the last year or so, that Salt House has been operating without a special permit, I guess, technically. And secondly, in that 2000 decision, valet parking was specifically required. That goes away because the Elm Street lot will disappear or is disappearing. So I don't know, that puts the parking allowed parking in jeopardy. I don't know the appropriate next step, but I think that maybe the owner should be made aware of the terms and conditions of that 2000 permit.
Well, yeah, particularly with the season coming on. I mean, people look forward to that place being open.
Yeah, but I mean, it's not that I want to be a Scrooge, but this was a decision made in the year 2000. I guess I was on the board then, but I don't remember it too well. I remember it somewhat. And as you all recall, well, as you know, for a year or so, the Salt House operated at about half capacity, at least outside, because they didn't have a parking plan. It was only when they came up with the valet parking and some spaces over in Elm Street lot that I think capacity expanded from 52 to 96. Not quite a doubling.
Mhm.
And that's gone away. So I think a new hearing is going to be required for the Salt House. And again, parking is probably going to rear its ugly head. My point of view on parking is that the town really needs a harbor parking master plan. Doing all this stuff is one-offs, and in another few months, we'll probably hear from the boat storage where the present Lobster Pound is and all that, and they want a boutique hotel, not enough parking. We're sort of incrementally in danger of compromising ourselves into gridlock. And I don't think that's much of an exaggeration. Border Street, as you know, is really narrow and there's no parking, supposedly, although there is. But I don't know. I feel compelled to suggest to John that he reach out, John Hallen, to the owners of Salt House and have them come back for a special permit, which is now null and void, as far as I see it.
Well, hi, Woody.
Hi.
Just a comment on that. I have reached out to them regarding a parking plan for valet parking. So they should be coming forward with that information soon. I'm not quite sure where, what, how just yet, but they seem to have a idea for some plan in place.
Okay, it has to be in property they control.
Yes, yep, I told them that as well too. The only other question then would be if the valet parking is taken care of, would be, this might be council, was that, so every time there's a change of ownership on the property, which could happen, a property owner passing away, a son taking over, a new LLC, whatever that is, that would be trigger for them to come back for the board to approve the new ownership of the property. Would that be correct?
John's asking the question of you, Joel, I think.
Yeah,
You know, that's, I guess that's how I'm in reading the decision over. I just got a hold of it today, but it seems to be the transfer itself. So that whoever the new applicant would come back again for essentially asking the board for permission to have all the rights that go with the transfer and new ownership. Okay.
well, so of course I haven't seen the decision, but that would be a legal condition in a special permit. If that was written into the special permit, it's a legal condition and enforceable. And usually it's written in a way that essentially the new owner, the prospective owner comes in and essentially gives you their credentials and tells you their plans. There's case law that says that you can't dramatically change. I mean, if the project is the same, you can't dramatically change the conditions. But essentially, the point of that is to make sure that the new owner is aware of the existing conditions and just get them to acknowledge that whatever they may be, they're going to abide by them.
Yeah, I think this situation is made more problematic because some approved parking has disappeared. Required parking has disappeared, I should say. And the board never, I'll have to think more about Atlantica because our records aren't great, but there's some reference to it. But the Salt House certainly, never gave if you will, a waiver for the number of parking spaces. It simply said that they had to have, X on site and Y in another site that under the same ownership that could be accessed via valet parking. So
Yeah.
they never gave a variance, if you will, for parking spaces. They were quite specific about that. So that complicates matters now. I doubt that the owners really have been aware of that.
No, not until recently, and I believe they seem to indicate that they have the
If they can
valet.
solve it, great. I mean, I think. it all-
Yeah, they seem to think there's a valet park in there, but that would just require them to come back to seek permission from the board
Sure.
for the change of ownership. So I want to make sure I tell them, why, what they have to do.
Yeah, well, when it says non-transferable, I think the whole special permit is not transferable without a hearing, and the special permit included parking as well as who the owners were. I believe. I could be wrong, but I don't think so. Anyway, we just want to, we want to be transparent, and if they can solve it, I mean, great, because it's an asset to the town, but
Right.
Parking really bothers me down there anyway. I mean, it's just nobody's wanted to bite the bullet and come up with a master plan.
So I should clarify, I may have misunderstood John's question. So does the special permit actually say it's not transferable?
Yes, I believe, right, John?
Yes, going back probably January, February, March of 2000, and then I think in the final draft, non-transferable was added to, and that's how it was filed with the town clerk in probably May of 2000. The final statement being non-transferable.
And this whole decision, of course, went to the appeals court twice.
Oh.
And was affirmed twice by the appeals court. The then owner was objecting to certain conditions like parking. And the appeals court upheld the zoning board. Now, they didn't kind of carve out the non-transferable. That was in the decision, but they affirmed the decision, as appeals courts are wont to do without a lot of rhetoric.
Well, they just addressed the question that was before them, and it sounds like that wasn't raised as a issue on appeal. So I'd say that the property's sold. The new applicant's got to come in and apply for a special permit, but starting from scratch.
Yeah, and I think there's been 2 sales since that time. So,
well, whatever. This probably wouldn't have surfaced if it hadn't been for the Atlantica thing. But I think they're going to have to come in.
Yeah.
The special permit speaks about operating hours, so on and so forth, handicap spaces, bar stools, no paper or plastic containers. It's pretty detailed.
yeah, and I think if they're able to address the valet parking issue, which they indicated they have, it seems the only issue that they'd be asking for relief from is the change in ownership.
I think we'd have to probably confirm that the parking plan is, adequate.
Right.
We wouldn't object to a compliant parking plan. We can't. So at any rate, they're probably going to be advised. They should be advised that they should come before us, I think, and clear this up. I don't think they want to operate without a permit.
No. So, all right, they will.
So that's just a FYI. Okay, well, I move that we adjourn unless there's other board business.
You need to approve the minutes from the March meeting. Or not approve, but you need to vote on it.
Oh, okay. I thought we did do it. Okay, we didn't do it last meeting.
No.
All right, does somebody want to make a motion?
I move we approve the March minutes as written. I looked through my any issues.
Yeah, I went through them. Moved and seconded, all in favor, Woody Chitik, aye.
Dave McMorris, aye.
Carl Higginson, aye.
Lee Darcey.
Michael Dickey, aye.
Matt Watkins, aye.
Okay, moved and seconded, and we will see you. Joel, are you going to be bowing out, or are you going to be staying with this merry group until we wrestle this one to the ground?
Yeah, and it's a merry group indeed, but no, I guess I'm gonna hand it back to Carolyn.
Okay,
But we, yeah, saw the key issue through to the end, and I'll bring Carolyn up to date, and I'll be happy to fill in again as needed, but
I really appreciate your advice and counsel, really. It's been clear and, easy to understand, so I appreciate it.
great. Thank you. My pleasure working with everyone.
Well, you ever get bored? It's always another seat at the Zoom table. Okay.
Good to
No,
know.
have a nice month anyways. Thanks,
All
Joel.
right.
Okay,
Good night, everyone.
good night.
Right.